All right, we're back on the record, and I believe one of the issues we were going to talk about was the juror. I believe it's number 132, Sergio Aguiar. That's the one that I believe I've noticed sleeping, and counsel had noticed sleeping. And are we in agreement to?
Judge, there were two. We're in agreement on both of them, and I think Bobby and Kevin said yesterday that they didn't care. It was us that had left.
What was the other lady's name? Was it Mary McCrite?
Mary McCrite, yes, sir.
She sits over here, right?
Yes,
Yeah,
she's
older lady.
In the back row. So that's going to leave one. I guess we need to wait for Kevin and them to get here, and we'll do that draw, and we will tell whoever that person is that they are the first alternate if we should have a problem.
Yes, sir.
And then I guess, do you all want to put Sergio at the end as number 3?
Yes.
I would pick McCrite as number 3, but yeah, we'll cross that bridge when we get there.
Yeah, let's just wait till we get there. And
hopefully our luck's not that bad. We got bad luck, but that's taking it to an extreme. Yeah, that's taking it to extreme. So.
And Judge, just for purpose of the record, if we could put on the record we discussed this with our client.
Yes, we got here early to do that. Yes, sir.
And one thing I wanted while we're on the record, Lawson's instructions are the same exact thing. And yesterday when I was reading, come on up. Yesterday when I was reading the instructions on Mr. Houck's case, I noticed that it should have said number 3 instead of number 2, and I made that change. Just wanted to make sure that was
I think you read that out.
I read that.
Yes,
and also saw another thing. Under complicity to murder, it doesn't have the A. The next page it has B and C.
Yes,
and
sir.
I have written in A and initial that. That's the only change. Just want to make sure everybody was aware of that.
Yes, sir.
George?
And we told them that you all were okay with the 2.
We said yesterday with the 2.
Yes, we agreed to that today.
Well. Okay.
That's the only thing we talked about.
Do you all want to go ahead and draw then the other person?
That's fine with us.
My understanding is the clerk, and she sealed this up, has got all 15 chips in here. She just sealed it well.
What's that?
Any winners on your all throwing last night?
I didn't look. I got to look tonight.
Seals stuff. She
seals
seals it well.
No. You want me to look for scissors?
It's open. I think.
Well, just don't hurt yourself.
I don't know where she got that envelope, but it's impressive. Okay. And I consider this open court. Are you all fine doing this without the jurors in the room since we got the other two that we're not?
Yeah, I'm fine.
Does anyone want to draw out who the person is?
You could be it's your courtroom.
Okay, well, let's see.
I'll probably pull out Mary McCrite.
We pulled out 78. 78 is a Richard Parrish. I don't know which one Richard Parrish is.
I don't either.
But he will be our first alternate. So I'm going to show his first alternate. I'm going to show the other 2 were alternates by agreement.
Yes, sir.
Okay. I just hope Mr. Parrish and Miss McCrite and Mr. Aguiar aren't mad that we're sitting here for 9 days.
I don't think Mr. Aguiar will probably care.
No.
Go home, go to sleep.
Yep. Get some rest.
And there's the 78. All right, very good. Well, we'll let the jurors know when they come in. Thank you all. At this time, let the record reflect all 15 jurors have returned to the courtroom. Everyone may be seated. Thank you. All right, ladies and gentlemen of the jury, what I need to talk about first is before we announce who the alternates are. We've already done the draw here this morning. Is there any juror that's having any problem right now as far as sick or not able to continue serving? Just want to make sure before I let you know about. You weren't raising your hand. You were just doing the back of your hair. Okay, just making sure over there. Who these three people are going to be, I'll announce here shortly. But I also want to tell you that you're not finally excused yet. And let me read the rule on recalling alternate jurors. The court may require alternate jurors to remain sworn and subject to recall after the jury retires to deliberate, provided they have been properly admonished. If recalled, the court must ensure that an alternate has complied with the admonition. If an alternate is recalled after deliberations have begun, the court must instruct the jury to begin its deliberations anew. Alternate jurors shall be recalled in the same sequence in which they were excused. So, whoever the three people are, the same admonitions are in place. Do not discuss this case with any of the jurors. Do not let anybody talk to you about the case. If anybody attempts to talk to you about the case, I need for you to immediately report that to me. And you're not to finally make up your mind until you've gone into the jury room and considered what your fellow jurors have to say about the case. Of the 12 jurors who will be selected, the bailiff will be collecting cell phones and smartphones because you can't have any type of distractions. It can't be doing any research. He's got a telephone number that he's going to give you, and primarily has given you all, that in case let your family know if there's some type of emergency that happens today, we'll get an alternate in here. The last thing I want is somebody having a child that got hit by a car and you can't be there. So I want them to immediately contact that number and we will get you there, okay? Hopefully that will never happen, but I just want to have that as a backup plan. Whoever the 12 jurors are, when you go to deliberate, if there comes a point where it looks like you're going to run into lunch, let the bailiff know what you want for lunch. He'll give you some alternate or some ideas of what they normally pick up here. If it's dinner time and it's getting close, send out, you want a midnight snack. I hope we don't get to that. Just let him know. So he will work with you on that. All right. At this time, I'm going to announce who has been drawn out as the 12 alternates. The first person drawn out that would be the first alternate is Richard Parrish. Who is Richard Parrish here? Mr. Parrish, okay. I'll let you go here in a second, okay. Remember, the same admonitions are in place. If anybody tries to talk to you, including the media, you can't talk about the case until it's been resolved. Sergio Aguiar and Mary McCrite. Okay. I'm sorry that you three are being excused. I don't want you to feel like you have wasted 9 days, 10 days of your life. But there's been a lot of times where I've had to use alternates because something has come up. We're going to let you all go, but remember those same admonitions are in place, and we've got your phone number, and we will let you know when the case is over today or tomorrow, whenever it's over, okay? So you three may go. For the 12 jurors that are remaining, these are the original instructions. The bailiff will be bringing those in with you. You will know the originals because I have signed those, and the verdict forms are attached. We will send in all of the exhibits that have been introduced, and I'm going to need the bailiffs who are going to take charge of the jury to come around for their oath. You all will raise your right hands for me. Do you swear or affirm that you will take charge of the jury, that you will not allow them to separate, that you will not allow anyone to communicate with them about this case, and you will not attempt to do so yourself?
I do.
Thank you, guys. All right. Deputy Harris, here are the instructions. Fran will give you the exhibits. You may go with the bailiff, lock at the door if you want lunch, or you reach the decision and let him know.
Bring your notebooks here.
Everyone may be seated. one thing I want to talk about first. I don't have any idea how long this jury will be out, but one thing I want everybody to be thinking about is when they reach their verdict, the court expects everyone to remain respectful and quiet in the courtroom. There's not to be any outburst. There's not to be any cheering, booing, no noise at all. And let me explain why. These people have been listening for 10 days. They're trying to continue with their life at the same time. They've got families, they've got jobs, they've got responsibilities, and they're being paid $12.50 a day to sit here. And when I began this trial, I told everybody that everybody that comes through the courtroom is entitled to a fundamentally fair trial. And whenever we have human beings involved, no one is perfect, and neither are these jurors. And I've had cases before where there's been outbursts in the courtroom, and I had one that was really bad, probably about 5 years as a judge. And somebody started approaching the bench, yelling and screaming, and I looked over at that jury, and they had horrified looks on their face. And the bailiffs had to drag this person out of the courtroom. The person was in a holding cell and was beating on the wall so hard that the cameras were shaking in the room. And after that trial was over, I felt compelled to talk to those jurors to find out how that experience was for them. And it was awful talking to them. Some of them told me that they sat in their car crying during lunch because they thought they had done the wrong thing. Some of them told me they couldn't eat their lunch. They're human beings like everybody in this courtroom, and they're going to remember this trial in these 10 days, and it's not going to be easy for them in that jury room. So I'm going to make sure everybody's respectful of these people because they're doing the best they can under the circumstances they've been given. So like I said, when they come in, I expect everybody to be respectful, whether you agree or disagree with whatever their verdict is. I know there's a lot of tension in this case. We've had outstanding security throughout this. I can't say anything other than the Warren County Sheriff's Department has been outstanding. Darren and the Administrative Office of the Courts, your staff has been outstanding. They're going to have certain requirements when this case is over about how people are going to exit this courtroom, and we're just trying to keep everybody safe. That's my main thing, is keeping everybody safe. I know the media would like to have cameras outside this courtroom, but that's going to stop people, and I don't need words exchanged, and I don't need problems. So they're going to come up with ways to get people in and out of the building. I expect everybody to comply with what security does. I'm not having any role in that. They're the security people. They're the people in charge of that. So I'm going to have them make the decisions on getting everybody safely out of this building. As soon as we have a verdict, we'll let the attorneys know. I don't know if you all want to, if y'all going to stay in the building or walk down the street. If you want to give me cell phone numbers that we can contact, if you want to be close by, I'll be glad to do that too. So once we have a decision, we'll let you know. So I'm going to show courts in recess until the return of the jury's verdict.
Judge, can we approach?
You certainly may.
What's the reminders that they walked out with?
That would be the
one exhibit.
one exhibit. Do you want to gather those up?
Yeah, I would
It's been
object.
introduced in there.
I would.
so-
I mean, obviously, I don't object to the one that's
Okay.
introduced, but I don't think they should all have a binder.
There
That's
was a binder that they had. It's been introduced, but I need all the binders. Tell Barry we need all the binders, but that's been introduced if they want to see it. I don't know what number it is, but they can definitely do that.
Yes, sir. I think if it's the statement, it's in.
Well, there's one binder over there that I can see. But
So they have them as an exhibit also, so that's fine.
Okay. Yeah, I just don't want that one thing to go back and
we
be different.
will get those.
Thank
I'm
you,
sure right
Judge.
now they're all texting their family to
Perfect.
let them know they don't know when they'll see them again.
It's up to the judge.
What's that?
He.
Shane, I don't know if there's something else they're wanting to discuss.
I would like to go back to the hotel. I'm indifferent, but
Well, I prefer not to go that far away.
Well, I mean, would the court be okay with us zooming back in for juror questions to the courtroom, or?
I think we need to be here in person with your client. Yeah, I don't think we need to be on Zoom if we've got some question from a juror. I think, especially if your client wants to confer with you.
That makes sense.
Creates problems. Okay.
Thank you, Judge.
If you want to leave any phone numbers for Fran, if you
Oh,
wanted
yes.
us, she can text you. 12 hours, yes, sir. If they can keep their notes, notepads. Okay, Frank, we can see it. We see counsel on the bench. It might be better instead of shot across the room. All right. Question number 1 is, can we have a laptop to review and listen to evidence? And question number 2 is, can we have the big paperboard and markers?
Well, I think we can have a paperboard
Paperboard
and markers,
markers.
I
but
think
a
the-
laptop.
I don't know if they're talking about what's on the paperboard.
I think they can
Oh.
have a blank one, but
That's what I
I
thought
I
they
think-
want a
meant.
blank one.
yeah, I think
Yeah.
they
They
can have
want
a
a
blank.
blank when they
Do we,
write
ha-
stuff
do we
up.
have a blank one?
We can take the pages
I
off
have
that.
all
Pull the
one.
papers off the one we got.
Well, why don't we pull the papers off that, and that'll give them that. As far as can we have a laptop to review and listen
The
to
answer is
evidence?
No.
Yeah, I
They
agree.
can
I
come
think
back in
I think they
here.
can come back in the courtroom
And listen to
and
evidence.
listen to it.
Yes, sir.
Do you all have a problem with me writing that on there?
No, sir.
Say.
I would just prefer you say you can't have a laptop.
Well,
I think they can
need
come
to be
back
able to know
and
they can listen.
they
to-
can come back
they
and
can come back
review
and listen to
testimony or
that.
any evidence they want to see
But
here.
if you're going to put that, I think you have to review the entirety of every witness you want to see, because they can't come back in under the
I
Kentucky
don't think they
rules.
have to listen to the whole trial
right.
again.
No, if you say I want to listen to the Teresa Young testimony, I think you have to listen to the whole thing.
Well, I don't know what they want to listen to, so we can take that up. At,
Yeah.
That's fine.
So right now, I'm going to show. Can we have the big paperboard and markers? Okay. We are sending in
get my trail
Requested items.
the paper board and markers. Okay, I'm change that to. We are sending in a paper board and markers. And on the laptop question, I'm going to write, let me see. Let me find it right now. First, we'll put it on here. Can we have a laptop? We cannot provide you with a laptop. However, if you want to review evidence needing a laptop, we can do that in the courtroom.
But I think if you don't mind, I think you should say, but if you want to watch a witness, you have to watch it in its entirety.
Let's just take that when they ask to see something.
Okay, look, we cannot provide you with a laptop. Okay, the question is, can we have a laptop to review and listen to evidence? We cannot provide you with a laptop. However, if you want to review evidence, you will need to let us know which evidence you want to review, and it must be done in the courtroom.
Yes.
Yeah, and Judge, I'm gonna. Are you? And I think part
I'm
of the
just
problem.
out some. I haven't
Yeah,
written
I think part of the problem is because we introduce, whenever we play like statements or anything, we always introduce a flash drive that ends up in their evidence pile. And I don't know if the court has a tendency to just play that back when the jurors come in, or they want somebody to stick it in a laptop and play it back on the TV. The only thing I would say is we tendered that 781, and we'd need to do the playback that was in the court if they asked to review his statement, because
Let's
I
wait
forwarded
until we
it.
find
Yes,
out
sir.
whatever they want to do. But here's what I've written down. Where's Kevin and?
They're getting markers.
Oh, they're getting markers. Okay, I just want to make sure they hear what I'm doing. Okay, this is what I've written down to answer. Can we have a laptop to review and listen to evidence? We cannot provide you with a laptop. However, if you want to review evidence, you will need to let us know which evidence you want to review, and it must be done in the courtroom. Everybody okay with that?
That's fine, yes, sir.
I've got it as generic as I can do.
Yes, sir.
And I will give you all a copy of what I'm sending back also, okay? Yes. Okay. The jury wants to watch Charlie's testimony that was given in court. We only had one Charlie, I believe that was Gerber. And the other Charlies were there. Okay, so I guess we should open up and let people come back in.
It's open.
As far as
The doors
public?
are unlocked, yes, sir.
Okay, I don't know whether they want to be in here or not, as far as the public's concerned, but we'll go ahead and I'll have the girls get that ready, and we'll have them brought in here shortly. To
Yes.
introduce that.
Thank
Okay. They can open the doors, yes. Okay. Fran, they're going to want to watch Charlie Girdley's testimony. How long do you need, Brandy, to get that ready? You remember which day Mr. Girdley testified?
Monday.
Monday of this week, right?
No, well.
Of last week, okay. So that was, the date was the 30th? Is that everybody's remembering?
30th.
30th.
I mean, it doesn't matter. If they can hear it, they can hear it. Yep,
If the bailiffs could gather up those folders out of the seats so they don't take that back with them. Brandy, do you know how to play back on this system? So you get to put on the video. Counsel, it's my understanding that the system here does not play back. It does in my three counties, Nelson, LaRue, and Hart. We have no problem playing it back, but apparently we're going to have to play it off the computer from the disc that was done here today, or the track. So, I think Brandy's getting them to hook that up to play Charlie Girdley's testimony.
I have this copied into my computer already, so I should be able to just play it from the computer. We have
They can use the headphones.
I didn't bring any of the extra equipment, so.
Yeah, we can. If you need to. Do you want to put those out? Where at? The neighbor's transfer.
Yeah, that's fine if they want to use them. I don't know if they need them.
So we would take, which is.
Oh. What do we do about the bench conferences?
I'm sorry?
That playback's going to capture those bench conferences on there also.
Okay, so we're going to need to silence it when we have a bench conference.
Yeah, I think that's 12.
Did we have many bench conferences during Mr. Girdley's testimony?
Probably not.
I know there was one.
Which day? June 30th? Looks like we must have taken a break sort of shortly after. Yeah.
Yeah, he was sitting.
Okay, gotcha.
No, he's sitting there, not there, and there, and there. That's right. My bad. But
So, you'll just be.
No, not in first.
Nowhere?
Not in first.
Switching on the monitor and test it out. It might be on, I don't know. It's just like,
Oh, congratulations. Yeah, that's great. All right. That's a good job. That's a promotion.
oh, great, thank you. Just mute it while the meeting is going to be just
Yeah, right, yeah.
if anything, I'll just unplug the cord. It's always my prayer glass in case of emergency. And if the water just keep watching, just let me know if you see it coming
Oh, man, yeah.
Let me test the sound and see how it is, because the sound is in there.
Yeah, I was gonna say, he's loading lunch. A couple of 20-pound pizza. That's important. Just a quick version.
How long is this? Like 2 hours?
I don't know. We took a break in there too, so I don't know how long.
It was pretty long.
How long it ended up lasting. So.
I was just going to tell the court, I know that Mr. Butler said that they have to watch the whole testimony. I don't think that's accurate. Roberson says they can watch whatever portion of it they wish to watch. They're not required to watch the entire testimony. I'm reaching right down the site on the case.
Well, right now, my note doesn't say they want to watch something
No,
in
and
particular.
it doesn't. I'm just in case you get the indication that that's in any way, shape, or form that give the court that case.
Right now, it looks like they want to watch the whole testimony.
Yes, sir.
That's the way I read that note. So, they tell me something otherwise, we'll come back. How about that? Are you ready?
May I test the audio first?
Sure, go ahead.
And this screen is stretched, and I can't see the buttons.
How long would it take to burn this DVD without the bench conferences and breaks? please raise your right hand? Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Sit right over there. Try to sit as close to the microphone as you can, and please answer all questions asked of you.
Mr. Gurley, I'm gonna ask you questions, but I'm gonna ask you to direct your answers to them, okay? Would you please introduce yourself to the ladies and gentlemen of the jury?
Charlie Gurley.
Okay, Mr. Gurley, and where'd you grow up?
In Bardstown.
All right. Do you still live in that area?
Yeah.
What I'm trying to figure out is if I should amplify the sound more, or if that's enough.
We'll let them use those headphones over there, and
Okay,
hopefully
great.
that'll help them hear
We
everything.
go back to the beginning, really, I think we're good. Are we on?
Do what?
Kevin's gonna help me with it too, but we should be ready to go to mute it. And I guess we'll mute it.
Are you ready for us to go ahead and bring the jury in?
May I have one more second?
Sure.
I just don't want the bench conferences to go wrong. Well, what I mean is, does that mean the conference ran for a minute, or does that mean? Let's go ahead, it's a couple of, I know, well, I have the exact videos that were gave us and the same that way, it's just a matter of, it's not broken for such conferences. Okay.
Ready? Bring the jury in, please.
Sorry, guys, can I sit here? Is that okay? Yeah, I think you get to sit there, so let's see what what I'm not gonna do is speak this to you. Thank you. And I just do it. So let me make sure.
At this time, let the record reflect the 12 jurors have returned to the courtroom. Everyone may be seated. Counsel, do you will waive the call?
Yes.
Okay. Ladies and gentlemen of the jury, I was given a note saying you want to watch Charlie, which I'm assuming is Charlie Gurdley's testimony that was here in court. Is that correct? Apologize about the delay, but the system I have in my 3 counties, we can play back from the system, but here we're going to have to play it from a laptop. But you'll be able to watch it. If you want to use the headphones, you're welcome to do so. We have to mute all the bench conferences. You're not allowed to hear what happened at the bench conferences. Please proceed. If you would please raise your right hand. Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Sit right over there. Try to sit as close to the microphone as you can, and please answer all questions asked of you.
Mr. Gurley, I'm gonna ask you questions, but I'm gonna ask you to direct your answers to them, okay? Would you please introduce yourself to the ladies and gentlemen of the jury?
Charlie Gurley.
Okay, Mr. Gurley, and where'd you grow up?
In Bardstown.
All right. Do you still live in that area?
Yes, sir.
Okay. And what do you do for a living?
Framing and remodeling.
Okay.
Construction.
Are you a carpenter by trade?
Yes, sir.
All right. And are you currently employed?
Yes, sir.
All right. Where you work?
Richard Weeks.
Okay. And are you a convicted felon?
Yes, sir.
Okay. And you have a conviction for possession of methamphetamine?
Yes, sir.
All right. And back in 2015, were you using drugs?
Yes, sir.
Okay. Are you clean today?
Yes, sir.
Okay. And how long have you been clean, Charlie?
Since 2023.
All right. We'll get to that in a minute. Does anything significant happen in 2023?
Went back to jail for absconding.
Okay. So I want to talk a little bit. Are you familiar with the defendant Brooks Houck?
Yes, sir.
Are you familiar with the defendant Joseph Lawson?
Yes, sir.
Okay. Does he go by Joey?
Yes, sir.
Okay. And back in 2015, who'd you work for?
Brooks Houck.
All right. And did you do carpentry work for him?
Yes, sir.
Okay. And were you framing?
Yes, sir.
All right. Now, how do you know Joey Lawson?
Worked with him before at Jim Hatfield Construction.
Was that before you worked for Brooks?
Yes, sir.
Okay. And did he work for Mr. Hatfield?
Yes, sir.
Okay. What about Steve Lawson? Are you familiar with him?
Yes, sir. Joey's dad went him through Joey.
Okay. So you met Steve through Joey, is that correct?
Yes, sir.
All right. Now, how long have you known Joey?
I guess 2014, somewhere around there.
All right. And Steve?
Right at 2015, somewhere around January.
Okay. Did they work for Brooks as well?
Yes, sir.
All right. Now, do you know when they began to work for Brooks?
I run into him in late May of 2015.
Okay. Did you see them before?
No, I ran Brooks.
All right.
Jobs.
And what were they doing for Brooks?
Skidster work, dressing up yards and stuff.
All right. So skid steer is kind of a term, right? Is that also known as a bobcat?
Yes, sir.
All right. And you said they were dressing up yards.
Mm-hmm.
Well, I don't know what that means, Charlie. What's
And
dressing?
they were grading out the yards and everything, getting them ready for grass seed and everything. Getting them all smooth.
All right. So when you all worked for Mr. Houck, were there several houses in the construction phase?
Yes, sir.
Okay. And there's different phases, correct?
Right.
Okay. The front end being pouring a basement or framing a house, is that
Yes.
correct? Okay.
Yes.
Would that be where you worked?
Yes, sir.
Okay. And on the back end would be doing the finishing work on houses, is that correct?
Right.
And getting the yard ready to seed?
Yes, sir.
Okay. And is that where Joey and Steve Lawson would be?
Yes, sir.
Would you see them every day?
No.
And are you familiar with Crystal Rogers?
I knew it was Brooks' girlfriend, and then I met her married a couple of times.
Okay. Was that on the job site?
Yes, sir.
Are you familiar with Rosemary Houck?
Brooks' mother, yes, sir.
Where do you know her from?
I met her up to her house when I was helping Brooks do a job up there.
Okay. And did she have anything to do with Brooks' business, if you know?
Not that I know of.
Okay. And are you familiar with Nick Houck?
I met him, but...
Okay. And where did you meet?
I met him up at Rosemary's house whenever I was helping Brooks.
Okay.
I met him that one time.
All right. And was he a police officer?
Yes, sir.
Okay. Was that somebody you wanted to hang around back then?
No.
Why not?
I was a convicted felon and usually had a warrant on me at that time.
Okay. Was Nick ever at the job sites?
No, not that I know of.
Okay. So do you remember the weekend of July 4th?
Yes, sir.
The Friday being the 3rd, the Saturday being the 4th. Do you remember that weekend?
Yeah.
Do you remember any conversation you had about Joey about Crystal's car that week?
He said he was buried with a skid steer, nobody ever found it.
Can you say it one more time?
He said he was buried with a skid steer, nobody ever found it.
All right. What about Steve?
Steve had come up to me and said something about Brooks wanted to get rid of his old lady. He wasn't the man for the job that I was.
All right.
I just looked at him and laughed at him and walked off.
The term old lady, I'm familiar with it, but who would he be referring to?
I'm assuming Crystal.
Now that third, did you work that day?
Yes, sir.
Okay. And was there anything going on that weekend that it's 4th of July weekend, do you have a usual routine?
I went to a pre-party at a friend of mine's house
Okay, pre-party?
to help him get ready for his party on the 4th.
Okay. And did you stay there?
I did for a little while, and then I left.
All right. How did you leave?
Joey picked me up.
Okay, and what was
Went to
he?
the bar for a little while.
Hold on, wait. What did he pick you up in?
300 Chrysler.
Okay. And then you were going to say you went somewhere, right?
Yes, sir. Went to the bar.
All right. What bar was that?
62 South.
Okay. Was it still daylight then, or was it dark?
It was still daylight. Stayed up there for just a little bit, and then went and met with Brooks and got my pay for that week.
Okay. You went and got paid, is that right?
Yes, sir.
Okay. Do you remember about what time of day that would be?
I can't give you an exact time. It was still daylight.
Okay. And do you remember if he paid you in cash or check?
Cash. Pretty sure it was cash.
Okay. And if you don't remember, Charlie, just...
I mean, I'm not real sure. But
Okay, that's
pretty
okay. I'm just saying, if
They
I
pay me
ask you
in
what-
checks sometimes. We pay me in cash.
What I'm saying is if I ask you a question you don't know the answer to, just you can tell me I don't know. Okay. Now, was anybody with him?
No.
Okay. Did Joey pick up anything?
Brooks picked him a set of keys. Joey said he had to work on Crystal's car, fit brakes and rotors on it.
Okay. Now, how long did that whole thing take when y'all met with Brooks?
Just a matter of a few minutes.
Okay. And where'd y'all go after that?
Went back to the bar and stayed at the bar for a few minutes. Then left the bar, went to my house. I took a shower and everything, got ready. And then we left my house, went to Joey and
Who's we?
Steve's.
Oh, who's we?
Me and Joey.
Okay.
And then went to Joey and Steve's place, picked up Steve, and went back to the bar.
All right. And where was Joey and Steve's place at?
Thompson Hill Road.
Thompson Hill Road. All right. And then where'd you go after that?
Went back to the bar. And then after I left the bar there, I left with my daughter and went back to the pre-party,
Okay.
where I stayed pretty much the rest of the night.
I didn't hear you. I'm
That's where I
sorry.
stayed the rest of the night.
Okay. Now, did you hear anything else from Joey that night?
At one time or another, I don't know, I'm not real sure if it was that night or before or after, but he said he would shave their head and pull their teeth and the hogs would do this.
Okay. Did Joey ever get a hold of you either that night or the next day?
I tried to get up to him to the city. His car broke down on the bluegrass that he needed help getting it off the bluegrass, and I told him I was drinking. I wasn't going to get a truck and trailer to.
Had he asked you to get a trailer?
Yes, sir.
Okay. And you told him what?
And I told him I was drinking and I wasn't going to get a truck or a trailer, and that time of night
Okay.
I wasn't driving.
Did he give you any idea where he was on the bluegrass?
I just turned the Bellwood ramps,
Between the Bellwood ramps?
Bellwood Road.
Okay. Is there
Hold
a
on,
Yeah.
one second. We got a juror that's having a hard time hearing this.
Sorry.
Who's having a hard time hearing that?
Charlie, you got to speak up.
Speak,
Do we have
okay.
any hearing? Do we have any hearing devices? How do we go for our hearing device? See if that helps her. Does that help any? Okay.
talking about Bellwood Road, right?
Yeah, there's
I'm not
two
familiar with Bellwood.
overpasses.
Is there an
Two
overpass?
overpasses that go across the bluegrass
Okay.
at different times. He just said he was in between those two.
And after that, did you go? You didn't go, right? Okay. Now, after that week, did you see Steve Lawson?
After that week, I'm sure I did. I mean, I don't know.
Was he working? If you don't know, Charlie.
I don't know.
Okay. All right. How about Joey?
I mean, I've seen Joey off and on, but I mean, I've seen him at work and off work a little bit. But
okay. Did you ever, after this, did you ever do any work at 345 past the Ballard Road?
That's Rosemary's house, and yeah.
Okay. And what did you do there?
I helped work pour some concrete up there to barn.
Okay. And was anything said about Crystal?
Rosemary said it'd been better off if she'd been gone long before she was.
One second. Who's got a juror that needs to use the restroom, so I'm going to take a break at this point, okay? Ladies and gentlemen, please remember the same admonitions. I understand this committee's go to the bathroom, so I'm not going to do them, but you all should know them by now, so make sure you follow the same admonitions. You're going to go with the bailiff. We'll take a 15-minute break and start back at 11, okay?
We'd ask you to tell the jury to disregard that last answer. You sustained that objection.
Judge, we didn't do that in trial. We can't start making evidentiary rulings.
I don't think I can do it at this point.
But you sustained it, and they've heard it, and that's the problem with it. I think they can't consider it because you sustained it. So otherwise, it's a tantamount to reversing your ruling.
Did I do it? Do we?
No, you didn't do it.
You did not admonish it, but you sustained the objection. But
I don't know, did the jury hear that it was sustained? I don't think.
no, they did not hear it was sustained. But we moved on, but he didn't finish the question, so it leaves the impression that that's okay, and that's not. And that's.
I don't think I need to do anything different than they're just asking to replay what we've watched before. So I'm just gonna. I'll note your objection.
Yes, sir.
Got a question, okay? The juror says we don't need to see any more footage, is what I've been provided.
And under that case, I think that's fine.
So,
What was it?
I'm gonna ask them to, if everybody's in agreement with that
Yes, sir.
before I send them back.
That's
okay?
okay.
it's our position they have to watch the whole thing. So
I'll move that.
Yes, sir.
I would agree with that.
I'll move that also.
Join that.
Okay, thank you all.
Yeah.
The note that I received from the juror says we don't need to see any more footage. I want to make sure everybody is in agreement with that. Everybody in agreement? Is there anybody who wants to watch more footage of Mr. Girdley's testimony? Okay, nobody does? Okay. Then we're going to let you all go back to the jury room. If you need anything, just knock on the door and let the bailiff know. Thank you all. Fran, I'm going to give you both of these notes to make part of the record. Court's again in recess pending the return of the jury. At this time, let the record reflect all 12 jurors have returned to the courtroom. Everyone may be seated. Counsel waive the call.
Yes, sir. Yes.
Ladies and gentlemen of the jury, it's my understanding the bailiff indicated that you all have reached a verdict. Is that correct? Okay. Who has the paperwork? If you'll get the paperwork from me, please. As I previously announced, there's to be no outburst in the courtroom when the court reads the verdict in this case. Okay. In regard to Commonwealth versus Brooks William Houck, in regard to instruction number 4, it says, we, the jury, find the defendant guilty of murder, principal, or accomplice under instruction number 4C. And under instruction number 5, it says, we, the jury, find the defendant guilty of tampering with physical evidence under instruction number 5. In regard to Joseph Lawson, the verdict form number 4 says, we, the jury, find the defendant guilty of conspiracy to commit murder under instruction number 4A. And under verdict number 5, we, the jury, find the defendant guilty of tampering with physical evidence under instruction number 5. In regard to Mr. Houck's case, does counsel wish for the court to poll the jury?
Yes.
I'm going to call each of your names, and if you agree with the verdict, please state yes. If you disagree with the verdict of 2 counts of guilty, state no. And I've got you in order here, and I apologize if I mispronounce anyone's name. You want a recess because you have things prepared?
Yes, yes.
How long do you need?
2 minutes.
Okay.
15 minutes.
15 minutes? Okay. Ladies and gentlemen, we're going to take a 15-minute break before we begin the sentencing phase, so be ready to come back in at 12:58, okay? Court's in recess till 12:58. At this time, let the record reflect all 12 jurors have returned to the courtroom. Everyone may be seated. Counsel waive the call.
Yes.
Okay. I believe that you had waived. Do you waive any opening statement?
No, if I could, I'd like to make a brief statement.
Okay, proceed when you're ready.
May it please the court, counsel, Joey, and ladies and gentlemen of the jury. For Mr. Lawson, it's always kind of difficult transition from first phase to second phase, and we've accomplished the first phase of the trial. This is now going into a second phase of trial, and while we do disagree with the jury's verdict, we do respect the jury's verdict. The question in this phase of trial is not whether Joey Lawson is going to be punished, but by how much. Okay, and he will be punished. And we talked about some penalty ranges, kind of at the beginning of the case when we did jury selection. And you'll hear Mr. Young's going to put on a witness who is from probation and parole. They'll talk to you about penalty ranges, parole eligibility. There's a statutory definition for what is called a violent offense, and you'll hear about what a violent offense sentence entails and kind of the repercussions of that. And for Mr. Lawson, his penalty ranges are 10 to 20 years for a conspiracy to commit murder, okay, and 1 to 5 years on tampering with physical evidence. You'll also probably hear, I believe, some testimony about running a sentence consecutive versus concurrent and things like that. And ultimately, what Mr. Lawson is asking for, this jury to recommend to the court as far as the sentence is 10 years on the conspiracy to commit murder and 5 years on the tampering with physical evidence. Okay, and we would also ask for that sentence to be run concurrent. So. And the reasons for that, if you all recall, there was some talk about mitigation and aggravation during jury selection. And what we talk about here are what are called mitigating factors. And for Joseph Lawson, you've heard actually a lot of those kind of things in the first phase of trial. You heard some aspects of Steve Lawson, his father. He obviously had a difficult upbringing. His father, Stephen Lawson, was a terrible role model. He's an alcoholic. And Joey resorted to substance abuse, and specifically methamphetamine. And you also heard some talk about a motorcycle accident. That motorcycle accident occurred in August of 2021, which resulted in his paraplegia, and that is why he is in a wheelchair now. He has no functionality to his legs, and right now there's been talk about doctors having to resort to amputation and things like that. So you will hear the probation officer talk about violent offense, parole eligibility. You'll probably hear some things about good time credits, statutory good time credits, so basically you all have an accurate understanding of what a 10-year sentence means, what a 20-year sentence means. And just so you all know, so the parole eligibility for a violent offense is 85% time. Okay, so what that means is that you will have to serve 85% of your sentence before you're released. In the context of a 10-year sentence, that would mean that service of 8 years, 6 months would have to be fulfilled before even being considered to be released. And then for a 20-year sentence, that parole eligibility is 17 years. Okay, and that is all just to be considered for release. Doesn't mean that you would be necessarily. So, I wanted to give you all that summary, right, of what is upcoming, and ask that Mr. Lawson be punished with 10 years on the conspiracy to commit murder and 5 years on the tampering as well.
Mr. Young, call your first witness.
Brian Hogan?
Brian Hogan.
Yes, sir.
Mr. Hogan, if you'll raise your right hand for me, do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
If you have a seat right over there, please sit as close to the microphone as you can, and please answer all questions asked of you. Mr. Young, proceed when you're ready.
Mr. Hogan, would you introduce yourself to the ladies and gentlemen of the jury?
Brian Hogan,
All right, Mr. Hogan, and where are you employed?
Kentucky Department of Corrections, Division of Probation and Parole.
Okay, and do you supervise individuals on probation and parole?
I do, sir.
Okay, and as part of your job or part of the Department of Corrections is to determine parole eligibility for offenses?
It is.
Okay, and did you bring the certified copy with you of that?
I did.
All right. So I want to go through these one at a time. We'll start with William Brooks Houck. The jury has convicted him of murder and tampering with physical evidence. Can you tell me the penalty range for murder?
It is 20 to 50 years or life in prison.
All right. And that means an individual can be given a term of years.
Correct.
Between 20 years and 50 years. So it can
Correct.
be 25, 30, 35, 40, 45, 50, right?
Correct.
Or any number in between.
Correct.
And then, or he could be given life. Is
Correct.
that correct? And I'm just going to talk briefly about parole eligibility on that. Is that considered a violent offense?
It is.
All right. And parole eligibility on the violent offense is what percentage?
85%.
Okay. So on a 20-year sentence, when would an individual become parole eligible?
On a 20-year sentence, somebody would be eligible at 17 years.
Okay. And at a 24-year sentence, when would someone become eligible?
20 years. That's
20
for
years.
anything 24 years up to and including life.
All right. So anything 24 years all the way up to life, they become parole eligible at 20 years.
That's correct.
So they would see the parole board on a 24-year sentence at 20 years.
Correct.
Or if they received a life sentence, they would see the parole board at 20 years.
Correct.
Now, that, whether someone's paroled or not, does anybody in this courtroom have any control over that?
No, sir.
Okay. And it's based on numerous factors that the parole board considers. Is that
Correct.
correct?
Yes, sir.
And one's behavior while they're in.
Correct.
Is that correct? And then on tampering, what's the penalty range?
1 to 5 years.
All right. And what's the parole eligibility on that?
15%.
Okay. Now, not to get overly complicated, but there's this term called concurrent
Correct.
and consecutive.
Yes, sir.
Is that correct?
Yes.
Does it really matter in this case whether they're concurrent or consecutive?
No, sir.
Okay. Because no matter what he's sentenced to on the tampering charge, it would be consumed by the time.
Correct.
By the time he's serving. Is that
On the
correct?
murder charge,
So
yes,
the
sir.
concurrent versus consecutive is really a non-issue in his case. Is that correct?
Yes.
Okay. So just to reiterate, at any time over up to life, the parole eligibility would be 20 years.
24 and up to including life.
Life. Yes, sir.
Yes.
And then on Joseph Lawson, he's been convicted of conspiracy to commit murder.
Correct.
Is that a violent offense?
It is.
All right. And the penalty range on that is what?
10 to 20 years in prison.
And I think his attorney spoke that the parole eligibility on a 10-year sentence would be 8 years, 6 months. Is that correct?
Yes, sir.
All right. And on a 15-year sentence, what would parole eligibility be?
15-year sentence is 12 years and 9 months.
Okay. And if it was between 10 and 15, it would be somewhere there between. Is that correct?
Correct.
Okay. And on a 20-year sentence, what would parole eligibility be?
17 years.
Okay. Now, he's also been convicted of tampering. And as we talked, that's a 1 to 5 year sentence.
Correct.
And it's 15% parole eligibility. Is that correct?
Correct.
Now, would the concurrent or consecutive change anything about that?
Not necessarily.
Okay. Let's talk a minute about concurrent versus consecutive. Okay. If a sentence, if the jury determines to run these two sentences concurrently, that means they both run at the same time. Correct. He would be serving on whatever sentence they gave him on tampering and whatever sentence they gave him on conspiracy to commit murder at the exact same time.
To show the jury, we basically say it one on top of the other. That's the easy way to understand it.
And if it's run consecutive,
end to end, one after the other.
But just to clarify that, he wouldn't have to finish serving the conspiracy to commit murder before he starts serving the other. Is that correct? Okay. It's just added on time. Correct. Is that right?
That's correct.
And if he received anything over I'm trying to think, a 10-year sentence would basically consume that, right?
Correct.
So if the concurrent versus consecutive really doesn't matter in this either. Is that correct? Okay. So no matter what the jury gives him, somewhere between 10 and 20 years, he would serve 85% of that, correct? On the low end, it would be 8 years, 6 months, and on the high end, it would be 17 years on a 20-year sentence. Is that correct? Yes. Okay, and we've talked about it. Nobody has any control over what happens with that. Is that correct?
Yes, sir.
And I know the defense attorney brought up good time credit, but that doesn't necessarily factor into this. Is that correct?
Correct.
Okay. Because it's a mandatory serve on 85%. Correct. Judge, I don't have any further questions for Mr. Coleman at this time.
Any cross?
Just a few, Judge. Good afternoon, sir.
Good afternoon, sir.
I just have a few questions for you.
Sure.
As you've testified, the penalty range on murder is 20 years to 50 years, any number of years in between there, or life, correct? You indicated that this qualifies in Kentucky law, under Kentucky law, as a violent offense, correct?
Yes, sir.
One of the things that means is that the defendant convicted of this type of a crime cannot ask for parole until they have served at least 85% of their sentence, correct?
Correct.
Another thing that means is that anyone convicted of that is not eligible for probation. Is that correct?
That's correct, sir.
They are also not eligible for shock probation, correct?
That's also correct, sir.
We've talked a little bit about parole. That's different than probation, right?
Yes, sir.
Probation means you never go to jail, but that's not an option in this case.
Correct.
Parole means you serve, in this case, at least 85% of your sentence, and then the parole board can release you on supervision after that, correct?
They can, yes, sir.
When an individual appears, when they are allowed to appear in front of the parole board does not have to grant them parole, correct?
That is correct.
And again, correct me if I'm wrong, but they have three options. They can either grant parole, correct? They can defer a person, and that is you serve some more time and you can come back and ask and maybe not next time, correct?
Correct.
Or they can do what's called a serve out, correct?
There's also parole upon completion.
Yeah, a completion of the sentence.
No, parole upon completion of programming. That's
Okay.
also an option.
That's also an option, but there's also a serve out, correct?
That's correct, sir.
Which means you can go to the parole board and they say, we're just, based on whatever factors they determine, we are just not going to parole you, go serve the rest of your sentence, correct?
They could, yes, sir.
And under Kentucky law, the victim's family has a right to have input to the parole board, correct?
Correct, sir.
Sir, that's all I have. Thank you very much.
Thank you.
Mr. Coleman or Mr. Boyd, any questions?
Yes, Officer Hogan.
Yes, sir.
Officer Hogan. Okay, so the couple things I wanted to fill in, or once you hit 85% time, it doesn't matter what sentence it was, but just talking about, if you were to be paroled, what supervision looks like, okay?
Okay.
So when you are on supervision or on parole, and let's be clear too, you cannot be on probation for 85% of the time sentence.
Correct.
It's only parole. So once you're on supervision, you have restrictions on your liberty, right?
Yes, sir.
And you have loss of privacy rights, right?
Some, yes, sir.
And what that entails often is you could be subject to home inspections by a probation officer, parole
Search and
officer,
seizure, yes, sir.
correct? And you also have you or have restrictions on carrying firearms or weapons, right?
Couldn't possess one serves a felony.
Exactly. And restrictions on travel,
Could, yes, sir.
right? And so you have to ask permission from your parole officer if you were to leave the state. You also can be subject to alcohol or drug screening, right?
Correct.
And you can be compelled to enter into substance abuse treatment.
Correct.
And that substance abuse treatment can also entail inpatient treatment.
Could, yes, sir.
Okay. You've got to maintain employment, right?
Yes, sir.
You gotta. You also always have to keep probation and parole informed of your address, in other words, your residence, where you're living, right? And so there's lots of terms and conditions of that parole, and if you violate the terms and conditions, you can be subject to what's called a parole revocation, right?
Correct, sir.
And a parole revocation would include essentially saying that you are now going to be sentenced to serve that the remainder of your sentence, right?
It could, yes, sir.
And then just other loss of rights, right? You've got, as a felon, convicted felon, you cannot vote, right, in the state of Kentucky.
Correct.
You can't hold certain professional licenses, right?
Correct.
And you also have increased difficulty in gaining employment just generally, right?
Could, yes, sir.
Okay. Thank you, Officer. No further questions.
Any redirect?
Just one to clarify. Mr. Hogan, I just want to clarify. On defendant Houck's sentence, anything over a 24-year sentence, it would be 20 years parole eligibility, no matter what. So if he got a 30-year sentence, 20 years, right?
Correct.
40, the same thing. Up to life. So even if he gets a life sentence, he would still go in front of the parole board at 20 years.
That's correct.
Okay, thank you.
Any recross? Any recross? May this witness be finally excused?
Yes.
You're finally excused. You may go. Call your next witness.
Kylie Fenwick.
Kylie Fenwick. Ms. Fenwick, if you'll raise your right hand for me, do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? Thank you, ma'am. Have a seat over there. Please sit as close to the microphone as you can, and please answer all questions asked of you.
Kylie, go ahead. You've already talked to the jury once, but go ahead and reintroduce yourself.
I'm Kylie Fenwick. I'm Crystal's second daughter.
Okay. And you're the second daughter, right?
Yes.
Okay. And are your brothers and sisters here?
Yes, but Eli isn't.
Okay. So go ahead and tell the ladies and gentlemen of the jury about the kids that are here.
My older sister Ashley, she's here. Then me, and then my sister Tori, and my brother Trenton.
All right. And I think you had testified earlier that you used to babysit Eli once, right?
Yes.
Okay. And how long has it been since you spent time with Eli?
I honestly don't even remember. Since the beginning of where my mom went missing, they never let us see him again.
I want you to talk about your mom, because you testified you and your mom were really close, right?
Yes.
And we didn't talk about this when we started, okay? But I want you to tell them what it's been like.
It's been really hard. My mom wasn't there to see me go to high school, graduate high school. Sorry.
Did your sister get married?
Yeah. She didn't get to see me go to college, get my degree, get my first job. She won't see me get engaged or get married or be there when I have kids.
And who have you all been raised by?
My mama.
Mama?
And my people.
Okay. And is there It's been hard, is that right?
Yes, it's very hard.
And you were the last one to see your mom, right?
Yes.
Of your kids?
And I never thought that would be my last goodbye.
Is there anything else you'd like to say to the jury?
We had a long time for this. I just want you all to be fair and go with what's in your heart.
Thank you very much, Holly.
Thank you.
Hold on. Is there any cross? Any cross? You may step down. Thank you. Any other witnesses, Mr. Young?
No, sir.
Any witnesses you wish to call at this time on behalf of Mr. Houck? Any witnesses you all wish to call? Okay. Let me see counsel at the bench. Randy, do you have those copies? Do you have those copies? During the break, I emailed you all that. I don't know if anybody received it or not. She's got a copy of it, so you all can review the instructions there. They're pretty standard. One of the Houcks needs to go to Mr. Young there. I'm sorry. Thank you. There's Lawson's. Pretty standard. So. What I will do is read the instructions to the jury, and then we'll go closings just like we did before. Anything else we can take up at the bench over here?
No.
All right, thank you all.
Judge, if we could get that podium out again.
Move the podium out. Sure. If we could have the podium back up here, please. Mary, you can give them a copy of the instructions for the sentencing phase. One for each defendant. The bailiff is handing out the instructions for the penalty phase. You should have one for each defendant. And once everybody has it, I will review with you what it says. You got one for each. Does everybody have two sets of instructions now? We'll start first with the one that says Commonwealth versus Brooks William Houck. Does everybody have a copy? Sure, before I read, everybody got a copy? Good. Okay. Mr. Houck's instruction says the jury is instructed as follows. It is now your duty to determine the punishment to be imposed upon the defendant. You have tried the defendant and returned a verdict finding him guilty of murder, principal, or accomplice, and complicity to tampering with physical evidence. From the evidence placed before you in that trial, you are acquainted with the facts and circumstances of the crimes themselves. You have now received additional evidence from which you shall determine whether there are facts and circumstances bearing upon the question of punishment. In your deliberations, you may consider the evidence presented to you in the first phase of the trial, as well as the evidence presented to you in the second phase. Instruction number 1. Pursuant to the verdict returned by you, finding the defendant guilty of murder, principal, or accomplice under instruction number 4C of the guilt phase proceeding, and under the evidence presented to you in both stages of this trial proceeding, you shall fix his punishment at confinement in the penitentiary for not less than 20 years, nor more than 50 years, or life in your discretion. Instruction number 2, pursuant to the verdict returned by you, finding the defendant guilty of complicity to tampering with physical evidence under instruction number 5 of the guilt phase proceeding, and under the evidence presented to you in both stages of this trial proceeding, you shall fix his punishment at confinement in the penitentiary for not less than 1 year, nor more than 5 years in your discretion. Instruction number 3, the verdict of the jury must be unanimous, and it must be signed by one of you as foreperson. You may use the verdict form below for writing your verdict, and I will sign and date the original. The verdict form will be attached, and it says, we, the jury, fix the defendant's punishment for murder, principal, or accomplice under instruction number 4C at confinement in the penitentiary for a term of, and you would fill in the years the foreperson would sign. Next, it says, we, the jury, fix the defendant's punishment for complicity to tampering with physical evidence under instruction number 5 at confinement in the penitentiary for a term of, and you would fill in the years there, and then you would sign as the foreperson. Then it says, now you are to recommend whether the above sentences are to be served concurrently or consecutively or some combination thereof. Concurrently means running together one with the other. Consecutively means running one after the other. Then it says, we, the jury, recommend the above sentences be served, and you would fill in concurrently or consecutively, and then there's a signature line for the foreperson. The second, yes.
This would happen. Are they, if they do give life, are they supposed to write that in there?
Yes. Yes,
okay. Yes, sir. I just
want
want to tell this.
Yeah, that'd be fine. Next, instructions to the jury in Joseph L. Lawson's case. The jury is instructed as follows. It is now your duty to determine the punishment to be imposed upon the defendant. You have tried the defendant and have returned a verdict finding him guilty of conspiracy to commit murder and tampering with physical evidence. From the evidence placed before you in that trial, you are acquainted with the facts and circumstances of the crimes themselves. You have now received additional evidence from which you shall determine whether there are facts and circumstances bearing upon the question of punishment. In your deliberations, you may consider the evidence presented to you in the first phase of the trial as well as the evidence presented to you in the second phase. Instruction number 1, pursuant to the verdict returned by you, finding the defendant guilty of conspiracy to commit murder under instruction number 4A of the guilt phase proceeding, and under the evidence presented to you in both stages of this trial proceeding, you shall fix his punishment at confinement in the penitentiary for not less than 10 years nor more than 20 years in your discretion. Instruction number 2, pursuant to the verdict returned by you, finding the defendant guilty of tampering with physical evidence under instruction number 5 of the guilt phase proceeding, and under the evidence presented to you in both stages of this trial proceeding, you shall fix his punishment at confinement in the penitentiary for not less than 1 year, nor more than 5 years in your discretion. Instruction number 3, the verdict of the jury must be unanimous and must be signed by one of you as foreperson. You may use the verdict form below for writing your verdict, and I will sign and date the original. The verdict form is attached. We, the jury, fix the defendant's punishment for conspiracy to commit murder under instruction number 4A at confinement in the penitentiary for a term of, there's a line to fill in years, a signature line for the foreperson. We, the jury, fix the defendant's punishment for tampering with physical evidence under instruction number 5 at confinement in the penitentiary for a term of, and you would fill in the years, a signature line for the foreperson. Now you are to recommend whether the above sentences are to be served concurrently or consecutively or some combination thereof. Concurrently means running together one with the other. Consecutively means running one after the other. We, the jury, recommend the above sentences be served, and you would fill that in, the foreperson, and then the foreperson would sign that. All right, as far as closings are concerned, Mr. Coleman or Mr. Boyd, proceed when you're ready.
May it please the court, counsel, Joey, and ladies and gentlemen, jury. I'll actually be pretty brief because I covered everything. I think most of everything I wanted to cover when I was doing the opening. All you've really heard is probably a repetition of what was said. You learn a little bit more about violent offender, 85% time, parole eligibility, but also things about even if you were to be paroled, that there is still punishment even while you're on supervision. Right? You have restrictions on freedom. You have restrictions as far as travel and employment and lots of things that are made difficult even after being paroled. And that's assuming that you would be paroled, because it's you also have the option, as the parole officer had mentioned, that they could make a decision where they say serve out the rest of the sentence entirely. Okay. So I did mention in the opening that what we are asking this jury to recommend is a 10-year sentence on that first count, which is conspiracy to commit murder, and 5 years on that tampering with physical evidence charge, which is the second count. And where you saw in the jury instructions where it gets that spot, consecutive versus concurrent, what we're asking this jury to do is just designate concurrently, which, as the parole officer mentioned, that means that the sentences run on top of each other or at the same time, so that the total sentence for Mr. Lawson is a 10-year sentence. That 10-year sentence would be at 85% time, so the parole eligibility date, again, that doesn't mean that he'd be released on this date, but parole eligibility date would be 8 years and 6 months. And the reasons why, as I mentioned in the opening, is that we heard lots of evidence about Mr. Lawson's upbringing with Steve Lawson. You heard things about him as far as his alcoholism and things like that. He was clearly a terrible role model, eventually Joey resorted to substance abuse. He's also paraplegic. He's wheelchair bound. I'll tell you, that is a restriction in and of itself, as far as movement and things like that. So for those reasons, we would ask this jury to recommend 10 years on that first count and 5 years on the second. Thank you all.
Mr. Short and Mr. Butler.
May it please the court, counsel. Ladies and gentlemen, the first thing that I want to tell you is that we absolutely respect your verdict. This was an incredibly difficult case. The attorneys here have had this for a couple of years and spent lots and lots and lots of time trying to sift through this case. This isn't a normal case that comes through as far as the volume of information, the conflicting stories, trying to sift through and see what happened. We watched you all as the trial went on, 2.5 weeks, and you all were attentive. You asked questions. You cared. And none of you asked to be here. None of you volunteered and said, I want to go make this decision in this man's life, his family's life. You got a jury summons and you responded. And we appreciate that. Of course, we see the facts different than you all do, but that's not our job. You all did your job, and we respect what you did. At this stage of the trial, it's much, much shorter, but it's extremely important. What we do here in the next few minutes determines a big part of the course of Mr. Houck's life. You're given some information to help guide you in what you think is appropriate. And one of those things is the penalty ranges. And as you've heard, the penalty range for murder in this case, the minimum penalty is 20 years in prison. He's not eligible for probation. He's not eligible for shock probation. You don't get out you don't have a chance to ask for parole until we're at 85% of that sentence. So no matter what happens here, Mr. Houck's going to prison for a long, long time. I want to talk just for a second about parole. I know you all were told all of this, but whatever sentence Mr. Houck receives, at some point, as Mr. Young indicated and the probation officer indicated, in Kentucky, it caps at 20, which means if it's a life sentence, in 20 years, he still gets to request parole. Any term of years, 20% up to 85% up to 20 years, he can request parole. I just don't want anybody to be under the false impression that that means he gets out of prison at that time. We don't know the answer to that. That's up to the parole board. They do take in, as he said, many factors into consideration. One of those factors in this case, it's very reasonable to assume is going to be the notoriety of this case, the impact that this case has had. And we would urge you to assume that any sentence that Brooks Houck gets, he's going to serve. He's not going to be paroled. Additionally, at this stage of the trial in a criminal case, the prosecution under Kentucky law is allowed, it's called truth in sentencing is the name of the statute. They are allowed to give you all information about a defendant's criminal history. You can't hear that at the beginning of the guilt phase of the trial, but you can hear it in the sentencing phase. And what that means is, if Mr. Houck would have had any criminal history at all prior to July of 2015, you would have heard about it. If he had been convicted of assault, domestic violence, drugs, DUI, weapons charge, anything, you all would have been given that information and allowed to consider it when you reach a verdict. Because the thought is we're going to look at a person's whole life, not just this one incident, and determine what's appropriate. You would also have seen any criminal offenses that he would have committed after the July of 2015 and given that information. You didn't get any because there is none. No criminal history of any kind before or after this incident. What we do know, and you're allowed to consider the evidence from the first part of the trial and this part of the trial, is that he grew up in Bardstown, he went to college, he worked his whole life, he supportive of his son, and that he has no criminal history at all. That's different than most criminal cases, quite frankly. When somebody is convicted of a violent offense, a serious offense, you see a laundry list of what they've done their entire life, harming people in the community. In this case, is the opposite. And ladies and gentlemen, I've done this for a long time. I was a prosecutor like these gentlemen here for a number of years, and then I've been in private practice for a long time. I've seen lots and lots of bad cases, murders, rapes, child abuse cases over the years. This case is different than most in the amount of evidence that you all were given and asked to make the decision that you all thought was appropriate in this case. Generally, in these serious cases, there's some type of piece of evidence that gives you a comfort level. There's a confession. There's a video of the incident occurring. there's DNA, there's some type of physical evidence that gives us all that comfort level when you reach this part to fix the penalty. That's not present in this case. Mr. Young, in his closing argument, in the guilt phase of the trial, said he was talking about reasonable doubt. The attorneys are not allowed to define reasonable doubt, as he indicated that. That's a strict rule for us. But then he did say it doesn't mean no doubt. And he's a really smart and experienced prosecutor. As you look at this case, anybody can understand beyond a reasonable doubt is what you all say it is, and we get it. But that doesn't mean no doubt. And you're allowed to consider any reservations at all in there.
I need to take a break. I think we need a juror that needs a break right now. I'm sorry to interrupt you, Mr. Shoring. Why don't we let the whole jury take a 10-minute break? Court's in recess for a 10-minute break. At this time, let the record reflect that all 12 jurors have returned to the courtroom. Everyone may be seated. You okay? You got warm?
Yeah.
We got some hand on you. Is that better? They took care of you? Good. All right, Mr. Shoring, counsel waived the call.
Yes, sir.
Apologize about interrupting you. Proceed when you're ready.
Thank you very much. Just got a couple more minutes. Ladies and gentlemen, as I was talking about, one of the things you all are allowed to consider when you fix the penalty range is, quite frankly, your comfort level and the level of certainty that you were able to discern from the evidence in this case. The legislature sets out penalty ranges. For instance, they don't say, for this offense, it's a 10-year sentence. For this offense, it's a 30-year sentence. They give ranges of penalties. And the reason that they give ranges is because the jury who sits and listens to the evidence is in the best position, after hearing everything, to determine what the appropriate penalty is. Ladies and gentlemen, 20 years is an incredibly long time in prison. Prison is never pleasant. It's not supposed to be pleasant. It's going to be particularly difficult for him because, again, the notoriety of this case. We're going to ask that, based on the unique circumstances and the level of evidence in this case, that you give him a 20-year sentence on this charge. Thank you very much. Mr. Gavin.
Ladies and gentlemen, jury, I want to echo what Mr. Shoring said. You all, I've never had a trial this long. Okay, I've been doing this 27 years. You all paid attention. You've asked questions that have flat out embarrassed me because I didn't ask them, and you paid attention, and we do appreciate it. And I want you to know the Ballard family who are sitting out here, they appreciate it too. Something the defense attorney said, playing on your comfort level, to me that's absolutely insulting. I'm just going to be honest with you. You made a decision. You can't stand up here and ask people to prey on your comfort level, okay? You all made a decision based on beyond a reasonable doubt. That is the standard in this case, and that is the standard you determined we met. And now is the time to fix the punishment. Murder. Joseph Lawson is convicted of conspiracy to commit murder. Conspiracy to commit murder. Trees, can you put a presentation real quick? Conspiracy to commit murder is participation in the murder. All right? You're some part of it, okay? And murder. Murder can be many things, okay? Somebody could be driving too fast. Somebody could have too much to drink and drive. Somebody could be so negligent or wanton in their conduct, they could accidentally kill somebody, but we call it murder. To me, the highest level of murder you can get is what you call premeditated murder. We don't have that in the state of Kentucky. It's not an element. But it's where you actually decide that we're going to kill that person. We're going to kill that person. And we're going to plan it, which is what happened here. It's exactly what happened here. Honestly, they were close to this being perfect, to being unsolvable. All went wrong when the car got a flat tire, and the call had to be made by Steve Lawson to Brooks Houck. They were close. This was premeditated murder. They planned to kill her, to get rid of her, and make it look like she just left. But there was a problem. Make it look like she disappeared. We believe that the plan began back in May, after Mama Houck, Rosemary, sitting right there, had asked Daniel Singleton to kill her, or asked if he knew of somebody that would get rid of her. I'm sorry. And that's when Steve Lawson showed up. Steve Lawson never reappeared after July 8th, after that phone call. They got rid of her. And what's insulting is if he had a problem with her, he could have just left her. But he didn't want to do that because he didn't want to lose Eli. So they got rid of her. They made her disappear. For 10 years last Friday, they got away with it. Joey Lawson. His participation was for financial gain. That's it. There's no evidence he knew Crystal. No evidence he knew the Ballard family. He simply did it for money. Think about how callous that is. There's no murder that's justifiable, okay? But you do have crimes of passion or heat of passion. That didn't happen here. This was a planned out, premeditated murder, and they were going to make it look like she disappeared. Him, his brother, his mother, they did it. And while we're talking about normally you hear, like Mr. Shoring got into, normally you hear about people's prior convictions. He has none. I don't care. Nobody has the right to take somebody's life. If you don't like them, leave them. But that wasn't an option for him. She was a good mom. She was a good mom. Look at that. It's her kid asking him, "Are you with mom?" No response. Nothing. Led those kids to believe and told those kids that story that mom left them. That she left them. She didn't leave those kids. She was a good mom. And what you normally hear is, in sentencing phase, in truth in sentencing phase, is somebody come in here and beg for mercy for the defendant. No one, not one person stepped up. Think about what Joey said, what Crystal meant to Joey. We'll shave her head and pull her teeth. Hogs can take care of the rest. I'll bury the fucking car and nobody will find it. He meant nothing. Participate in a plan to take another human being's life for money. Nothing. Greed. That's it. The defendant's family come in here and testify that they've been put upon. Put upon. That people treated them mean. Well, think about the Ballard family. They have to look at him every day. Look at him driving down the road knowing that he's killed their daughter. Those little kids sitting out there, they're not kids anymore, they're all adults. Those kids grew up without a mom. They've been sentenced to life in prison. He took the most precious thing in the world away from them. Think about it. Kylie, who helped raise Eli. She ain't seen him since then. These kids' lives were turned upside down for no reason at all. None. He paid Steve and Joey Lawson $50,000 so he could get away with this. Think about that. Worth $50,000. That's what she was worth. That's it. Think about those calls and texts that went unanswered. Think about those kids growing up without a mama. Their weddings, the graduations, babies. Their kids won't have a grandma. All because this man decided she needed to disappear. And misled the police for 10 years. You heard him. You remember this when you go back there and set the sentence. Okay? Remember when he's acting excited with Jon Snow on July 8th about the tip, when John tells him it's credible, and the next day he's telling his mama they're all jacked up on that bad tip. That hits home. She meant nothing to him. Those kids meant nothing to him. Nothing. And I'm asking you on Brooks Houck to impose a life sentence. He'll be eligible in 20 years. He doesn't need to be out unsupervised. If he gets out in 20 years, he sentenced those kids to life without their mother. They were lucky enough to have a grandmother to raise them. They mean nothing to him. And Joey Lawson, he doesn't even know her. It's going to help him get away with it. Serving 17 years for taking part of somebody's life, taking somebody's life, is not a lot to ask. I don't care if you're in a wheelchair or not. You're not sentencing Joey Lawson and he looks today. You're sentencing Joey Lawson back on July 3rd of 2015, who you heard. Mean. Not a good person. And I'm just asking you to render some justice. Justice for that Ballard family. They've been waiting a long time. Thank you.
I can have the bailiffs come forward. I need for you all to raise your right hands again. Do you swear or affirm that you will take charge of the jury, that you will not allow them to separate, that you will not allow anyone to communicate with them about the case, and you will not attempt to do so yourself?
I do.
Thank you. I'm going to give them the originals. You'll know which one the originals are because those are the ones that I've signed. That's the one that you all will need to return. Once you have reached the verdict, knock at the door and let the bailiff know that you all go with the bailiff at this time. Court's in recess pending the return of the jury. At this time, let the record reflect all 12 jurors have returned to the courtroom. Everyone may be seated. Counsel, waive roll call of the jury.
Yes.
It's my understanding you all have reached a verdict. Is that correct? I'll have the bailiff come and get it from the foreperson. All right. In regard to the defendant, Brooks William Houck, it reads under verdict form 1, we the jury fix the defendant's punishment for murder, principal or accomplice under instruction number 4C at confinement in the penitentiary for a term of life. Number 2, we the jury fix the defendant's punishment for complicity to tampering with physical evidence under instruction number 5 at confinement in the penitentiary for a term of 5 years. Then, under the recommendations of concurrent or consecutive, you have written in consecutively. That has been signed by the foreperson. Does counsel wish for the court to poll the jury on that?
No, sir.
In regard to Joseph Lawson, we, the jury, fix the defendant's punishment for conspiracy to commit murder under instruction number 4A at confinement in the penitentiary for a term of 20 years. It says, we, the jury, fix the defendant's punishment for tampering in physical evidence at confinement for 5 years. And then it states consecutively. However, the foreperson has not signed the bottom part of the consecutive or concurrent. So I'm going to send you all back to the jury room to make sure that's what is to be done and knock on the door when you're ready. So I'll let the jury. Everyone may be seated pending the return of the jury.
All rise.
At this time, let the record reflect all 12 jurors have returned. Everyone may be seated. Counsel, waive jury call.
Yes.
Can you have the form again? Okay. And I retained Mr. Houck's. It did not go back with the jury. The only form that went back was Mr. Lawson's. Okay. I will review that form here again to make sure there's been no changes. It says, we, the jury, fix the defendant's punishment for conspiracy to commit murder in the penitentiary for a term of 20 years. We, the jury, fix the punishment for tampering with physical evidence at 5 years. Then it recommends consecutively, and that all of those have now been signed by the foreperson. Do you all wish for me to poll the jury on that?
Yes, sir.
Okay. Anything else, counsel, that you wish for me to take up with the jury?
No, sir. No, sir.
Ladies and gentlemen, the jury, on behalf of everyone affiliated with the court system here, I want to thank you for your service. I know it was a hardship. It was 10 days that you all had to come up here. And I know you've been juggling a lot of things in your lives right now with work and children and all kinds of extra responsibilities. And you all paid really close attention throughout the trial. And with all my heart, we sincerely appreciate that. That's the only way we can resolve our disputes in this country. And you all certainly played a vital role in that. Leave your buttons in the back. They'll help escort you out. You're now free to talk about the case if you wish to. That's up to you. There may be media people trying to get in touch with you. That's your decision. Obviously, I always say, and I think it's best to say what they say in Vegas. What happens in Vegas stays in Vegas. What happens in the jury room stays in the jury room. But it's up to you all. You all have the right to talk if you wish to do so. You may go with the bailiff. Thank you. Everyone may be seated. The court is going to order a pre-sentence investigation report be prepared by probation and parole. As far as final sentencing is concerned, how far out did you all want to go for that date?
questions, we can go sometime in August.
We'll see what we can do in August. How long do you all think it would take to conclude, to do sentencing? A couple of hours. What about August 21st at 1 o'clock?
It's not the prosecutor's conference, is it?
I don't know when the prosecutor's
Yeah, I don't
conference
need
is.
it. I tell you what, let's just settle it then. I'll just leave and come do it if we need to.
I'm fine if you need another
That's
day.
all right. I got enough CLEs.
Okay. Is that fine with everybody else?
What time, sir?
1 o'clock.
Yes, sir.
That our-
August 21st at 1.
August 21st at 1 o'clock, is that okay?
Oh, I'm sorry, yes, Your Honor.
Okay, then I'll show final sentencing August 21st at 1 o'clock. I'm going to show at this time that the defendants will be in the custody of the sheriff and show that they're being held on no bond until we have final sentencing on August 21st at 1 o'clock. August 21st at 1. Anything else we need to take up prior to closing up today?
No, sir.
Okay, good luck to everybody. Thank you.
Folks, we'll take the interview, let the video out first.